Colleges of Law. It's debate night here at the Colleges of Law. This is a tradition that began in 2016 when our school started hosting debates on propositions, California ballot propositions. That turnaround, we had two debates, one on capital punishment and a second one on gun control. We came back 2 years ago in 2018 and had a debate on Proposition 10, which was rent control. So we've come back. We're going to be putting on 3 debates. Hopefully the word is getting out. We've been advertising on NPR and in other publications, and we'll have tonight's debate and program. We'll kick off the series on Proposition 25. We'll be back a week from tonight. It's going to be not to be missed. It'll be Proposition 16 on affirmative action from 5:30 to 6:30 p.m. Here on the same Zoom channel. So you will need to register for that if you're interested in participating. And then we finish the series 2 weeks from tonight on Proposition 22. And the shortcut for that one is that's the proposition on the gig economy. We have a terrific panel set up for that one as well. And so we have I think a terrific panel with us tonight. We have, if you originally signed up for the program, we announced that Senator Hertzberg was going to be with us tonight. Unfortunately, he had a family emergency and was unable to join us tonight. So we have John Bauters is going to be joining us. He's coming in out of the bullpen. He was given just a few hours of notice. And just want to acknowledge you, John, for taking this up and joining us and being part of the program. Of course, Robin Steinberg joined us when we first started this series, and just want to acknowledge you. And we'll do formal introductions in a few minutes, but just thank the both of you for being with us tonight and participating in this program. So I'm going to go into the housekeeping, how this works. And so there should be I'm going to launch a poll, and we have our participants are going to have the opportunity, it should be up on your screen, to vote. So if the election were to be held today, how would you vote on Proposition 25? Yes, no, or undecided. So actually, people are voting now. I'm watching the returns come in. So we're going to close this polling right before we go on to opening statements. And then we will we're going to do the poll again after the program and then see what kind of movement there is between the opener poll and the finished poll. And then our 2 debate participants, the person that had the most movement between the first poll and the second poll, will declare you our winner for this evening. There's no prizes. It's just bragging rights. It's just going home tonight knowing that you made the most persuasive argument for our participants. And so we're going to have, how the debate will work is still working to get our moderators in here. So we have the team working on that. And here comes one. Professor Smith has just joined us. And then we'll just give a little bit more time for the people to complete their polling. The numbers are still coming in, so I'll close that out. Welcome, Professor Smith. Can you hear us?
I can hear you loud and clear. Can you hear me?
We can hear you, and you're broadcasting from our Santa Barbara campus. We understand you're going to be teaching at 6:30 tonight. So
That's correct.
From our classroom. I'm just going to bring in our other panelist. We also have a special guest tonight. We're actually looking for him now. It's Assemblymember Rob Bonta. I'm looking for you. I understand you're with us tonight as well. So I'm looking to bring you into this conversation. As I mentioned before, Senator Hertzberg was unable to join us tonight. So his office sent over Assemblymember Bonta, who will be joining us tonight to just be part of this program as well. He's not going to be able to join us for the entire program, but we can have him for the beginning of that. I'm going to see if he's with us. I'm looking at our lineup here. Is this a Senator or Assemblymember Bonta? Can you hear us? Are you able to speak? Okay. Okay, we'll just, he's under 510, so I'll look to bring him in as well. But let's go ahead and get started, and we will, when Judge Eskin is able to join us, we'll have him, he's going to read an opening statement as well, and then we'll get the program started. But let me go into introductions. If you are a member of the Colleges of Law community, you're certainly going to know one of our moderators tonight. That's Professor Craig Smith. Professor Smith has been teaching for the Colleges of Law since, let me see if I get this year right, Professor Smith, 1984. Did I get that year right?
That's correct.
So welcome. We have a lot of graduates and students with us tonight. And if you are a graduate of the College of Law, you certainly know Professor Smith, so welcome. And he's going to be helping with the moderation of the questions that come in from the audience. And arguing, and I'll just do the introductions now, and then I will invite our participants, just if there's anything I missed in your introduction, you can just fill in. But arguing in support of Proposition 25, so yes for Proposition 25 on your ballot, is John Bauters. John Bauters is with us tonight from the Californians for Safety and Justice, a nonprofit organization working with Californians from all walks of life to replace prison and justice system waste with common sense solutions that create safe neighborhood and save public dollars. He's a former defense attorney who has worked on SB 10, the bill behind the end of use of cash bail. Welcome, John Bauters. Just invite you to share a little bit more about yourself.
Thanks, Matt, and thanks for inviting me to join you this evening. Apologies on behalf of Senator Hertzberg and Assemblymember Bonta, who could not be here at the late hour. But my name is John Bauters, and as introduced, I work at Californians for Safety and Justice. I've been an attorney for 15 years. I practiced criminal defense at Cabrini Green Legal Aid in Chicago. I now work on policy reforms and budget investments that prioritize public safety and mental health from a community-based standpoint over current incarceration models, and I'm happy to be here.
Thank you, John, and welcome, and thank you again for joining us on such short notice. Arguing against Proposition 25 is Robin Steinberg. She is the founder and CEO of the Bail Project, a national nonprofit organization that provides free bail assistance to thousands of low-income people every year while working to end cash bail and demonstrate continuity-based alternatives for pretrial support. I want to welcome Robin Steinberg to our conversation, invite you to say a few words.
Sure, thank you. I'm delighted to be here. Before actually launching the Bail Project in 2018 and beginning this work, you should know that I was also a lifelong public defender. And so I worked in New York City for most of my career as a public defender. I built a public defender's office called the Bronx Defenders, and then a public defender's office in Oklahoma called Still She Rises, and also co-founded something called the Bronx Freedom Fund, which was one of the first revolving bail funds of its kind in this country in 2007. So I come to this work, like John actually, with a real history of having been in the courts in and out and representing people and seeing the impact that cash bail has on people and the impact that it had on my clients. And frankly, I found, the system of cash bail to work in an unconscionable way. So it'll be an interesting conversation tonight, and I appreciate being invited. Thank you.
You're welcome, and thank you again for joining us. And just going to go into opening statements in a moment, but just a last call for anybody that hasn't completed the poll. We're up to more participants that have joined since we started the program. If you have just joined us, you can go to the polls at the bottom. You'll be able to pick if you're for or against or undecided on Proposition 25. We have a few more minutes to take those final poll results, and then we'll close out that poll. And so what we're going to do now is we're going to have opening statements in a moment, and then we're going to go have a moderated discussion. There will be an opportunity for each of our debate participants to have time allowing at least one question that they can ask each other at the end of that. And then we're going to go to the Q&A segment. So how the Q&A will work is you're going to be able to use the question and answer feature, and that should be part of your slate of tools at the bottom of your Zoom session. You'll be able to go in and ask questions there. And so we can, and then Professor Smith's going to be choosing the questions, and then we'll have the Q&A as part of the second half of the debate. And then we will complete the debate with a 1 to 2 minute closing remarks from each participant. We'll save a little bit of time at the end for a second poll, and so we'll see how persuasive our participants are tonight, and then we'll announce the results of our evening. So with that, I'm going to open our opening remarks for, so John Bauters, we gave you a few hours to work on this. You have 2 to 3 minutes to give your opening statement on why us, the voters of California, should be voting yes for Proposition 25. I'm going to open my phone here and start the clock. And with that, I'm going to go back to the polls, and I'm going to end the polls right now. So we've locked the polls. And John Bauters, over to you. You have 2 to 3 minutes.
Thank you. So today I'm encouraging everybody to vote yes on Proposition 25. At the outset, I'd like to say 5 things about Proposition 25 and why people should vote for it. First of all, Proposition 25 completely eliminates the predatory bail industry from California. It would be the only state in the nation to do that. We're the largest state in the nation, so doing this has national reverberations. Over 50% of the bail agents in the United States are located in California, and the United States is only one of 2 nations in the world that relies on a cash bail system, along with the Philippines, to determine pretrial release. So for that, we're making a huge progress as a state and as a nation in moving towards a more just and equitable system by eliminating cash bail. Second, Proposition 25 will definitely reduce pretrial incarceration in California. That's a question that gets asked frequently, but there's been a lot of different independent analyses that all come to the same conclusion, that incarceration will go down by tens of thousands of people pretrial every year at a minimum. The most conservative estimate, coming from the Office of Administration and Courts, estimates about 50,000 people or more would be released pretrial annually. The LAO, the Legislative Analyst's Office, which does the analysis annually for ballot measures, determined that they determined it would be a dramatic drop in pretrial detention, especially for misdemeanors. And the PPIC, the Public Policy Institute of California, in August said that they predicted 125 to 135,000 people more would be released pretrial every year under SB 10. The third thing is that Proposition 25 prohibits all forms of monetary obligations for people awaiting trial. So first, people can't be charged for their pretrial services, which would be put in place in lieu of the bail system under Proposition 25. Fines and fees that are currently levied against people for things in court, those are abolished under Proposition 25 in pretrial situations. And it would be the only explicit prohibition of this kind in the nation. So while several other jurisdictions have enacted bail reform, none of them have actually removed all the fines and fees, of which currently eliminating bail reform or limiting cash bail, but not eliminating the other types of fiscal penalties people face can be detrimental to people's ability to actually obtain meaningful release. Fourth, there's data collection and transparency in the decision-making that will make pretrial reform in California a lot more comprehensive and complete. So there's going to be annual public reporting required, including race and gender data that currently doesn't exist. There's going to be review and oversight of the instruments used under SB 10 and Proposition 25 by the assessment system and for pretrial release that doesn't currently exist. And when a judge seeks to detain somebody, there's going to have to be findings on the record. That motion will take place publicly, and the right to appeal or review will happen within 3 days. Finally, Proposition 25 is actually the product of more than 2 years of negotiations, and it's a compromise. We admit and acknowledge that Proposition 25 doesn't do all the things we would like to see in pretrial reform around bail, but it definitely opens the door, and it will not be possible to eliminate the bail industry if it fails at the ballot. Referendums establish a precedent for the legislative process. So legally speaking, if Proposition 25 is to fail, the courts would interpret that the voters' intent was to actually keep cash bail and commercial bail in particular, and it would be probably impossible for the legislature to further eliminate cash bail going forward. So there's neither really an opportunity for a legal or political redo in this situation. And while we share some of the concerns and we appreciate some of the advancements that have been made in the last 2 years since Proposition 25, when it was SB 10 had passed, referendums prohibit the legislature from taking further action until the voters have engaged. And so we're looking forward to having additional movement on bail reform and pretrial reform going forward.
Thank you. Just over 3 minutes. Well done. Terrific opening statement. So I'm going to reset the clock and bring in Robin Steinberg, your opening statement, 2 to 3 minutes.
Look, I should love this bill. After all, I've been fighting for racial and economic justice my entire career, both as a lifelong public defender and now as the founder and the CEO of the Bail Project. At the Bail Project, we work around the clock and around the country to prevent pretrial detention and put an end to the two-tier system of justice that cash bail creates. I admire the legislators for taking on this issue and for the courage that I know it took to stand up to the bail bond industry. And I'm not blind to the irony of being on the same side of the argument, although for very different reasons, as an indefensible industry that profits off of desperation and poverty. So before arriving where I did an enormous amount of soul searching. I'm not naive. I'm not so ideological that I can't see the forest for the trees. I don't believe that the perfect should be the enemy of the good. And I often do see the value of incremental change, even when I yearn for transformative change. But after a lot of reflection, I simply can't support SB 10 or Proposition 25. I could debate about the wisdom of lots of the many details found in the bill, but for today, I want to focus on two main issues that made it impossible for me to be where, frankly, I'd like to be. First, the foundation of SB 10 is algorithmic risk assessments. These are statistical tools that purport to predict what a person might do in the future, but what they actually do is codify racial disparities in the criminal legal system. And that's not just my opinion. It's the conclusion of many experts in the fields of statistics, data science, and law who have argued that these tools are fundamentally flawed. The algorithms are woven into the very fabric of the bill. Indeed, nearly every decision rests upon them. And here's what I know. A house that is built on an utterly flawed foundation cannot be repaired. You have to take down the whole structure and start again. So you can't fix it, you can't tweak it, and you can't make it better because the very architecture of SB 10 relies on tools that reflect entrenched racism. They're a fiction designed to cloak the reality and make us feel better about what is fundamentally an unjust system. And worse, they will cement the unconscionable racial disparities that we know exist in our system. Secondly, in order to actually implement these flawed algorithmic approaches, the bill creates a massive new surveillance and supervision bureaucracy that they call pretrial assessment service agencies. These will become expansions of a proto-law enforcement apparatus, creating probation-like conditions for people who have not even been convicted of a crime. And what we know about that is that historically, probation in this country sends people back to jail, not for reoffending, but in fact for technical violations like failure to miss an appointment. That culture is antithetical to the problem-solving, hands-on approach that we could take in the pretrial context through a more public health and community-based approach. So while I want to end cash bail desperately, and any industry that profits off the backs of poor people, replacing cash bail with algorithms will further entrench systemic racism in our system and make it more and more difficult to create meaningful interventions that break cycles of poverty and incarceration. And that's why I oppose Proposition 25. We have to do better before it's too late.
Terrific opening statements. And Judge Eskin, just in time, and wanted to welcome you, Judge George Eskin, with us today. He's our one of our program moderators. We went ahead with the program and did the opening statements. I went into the kind of how the debate works. So we got all of that housekeeping stuff done. So I'm going to turn it over to you. I know you have some questions for the panelists, so I'll yield to you. And I know you had a statement as well about bail. If you'd like to just speak to that, you can. But the program is yours, Judge Eskin.
Well, the introductory statement that I had prepared was really supposed to set a context in which the opening statements that John Bauters and Robin Steinberg have made would be perhaps more fully understood by the audience. Do you want me to present that introductory statement now at this point in time, or just proceed with questions to both?
I think you could build on the introductory statement if there's information in there or content or context in there that you'd like to bring into the conversation, please do.
I think it's important for all voters who are going to address Prop 25 to have an understanding of what bail is. Now, one definition of bail is pretrial release. Bail started as a way to get out of custody pending trial, but in the United States, bail has been transformed into a method for keeping people in custody despite our fundamental presumption of innocence. In the beginning, after the Magna Carta was signed 800 years ago in 1215, people who'd been arrested by a sheriff were no longer held in custody at the pleasure of the king. And a form of security or bail was introduced, frequently in the form of a neighbor's assurance that the defendant would return to court for trial by the magistrate. The United States Constitution contains no right to bail. Instead, the Eighth Amendment provides only excessive bail shall not be required, borrowing the language of the English Bill of Rights of 1689. When the Eighth Amendment was ratified in 1791, the commercial bail industry did not exist. As our population and mobility expanded westward across the continent, money replaced the assurance of neighbors, and the introduction of arbitrary bail schedules led to enormous expense associated with the cost of purchasing your freedom prior to trial. Insurance carriers provided a vehicle for defendants to secure their release. And by the end of the 19th century, just 120 years ago, the deposit of money or a pledge of assets became the principal condition of release as a commercial surety system was established. Today, the United States and the Philippines are the only countries in the world with a commercial bail system. Throughout the United States, the pretrial population in jail has increased dramatically as people remain in custody because they cannot afford commercial bail. And statewide in California before COVID-19, pretrial inmates constituted about 60% of the county population, and sadly, that hasn't been reduced much. The commercial bail system has also produced significant racial disparities. Statistics show that Black and Latino defendants are more likely to remain in custody pre-trial than white defendants and less likely able to post money bail. Pre-trial detention threatens employment, housing stability, child care, access to health care, and the disposition of the criminal case. Reform of the bail system has been introduced nationwide for more than 60 years, from minor legislative changes to overhauls of entire systems in states like New Jersey, New Mexico, Illinois, Kentucky, Oregon, Wisconsin, Michigan, and the District of Columbia. With the Federal Bail Reform Act of 1966, consideration of public safety became a factor in setting bail. In 1984, Congress mandated pretrial release upon an unsecured bond, unless such release would not reasonably assure the appearance of the person or would endanger public safety. And it authorized pretrial or preventive detention, which the Supreme Court found constitutional in the 1987 case of United States versus Salerno. The pretrial release system in the federal court starts with a detention hearing, where a judge determines whether to order release from custody along with appropriate conditions of release. Federal law provides that pretrial release must be available unless the defendant presents a risk of flight or a risk of danger to the community. If so, the judge must consider whether there are conditions of release that will mitigate that risk. Now, back in 2016, just 4 years ago, California Chief Justice Tani Cantil-Sacayue and the Judicial Council created a pretrial detention reform work group. Its charge was to look at how courts could better identify ways to make pretrial release decisions that will treat people fairly, protect the public, and maximize court appearances. The work group submitted its report in October 2017, recommending that the current commercial bail system be replaced by a risk-based pretrial assessment and supervision system. Meanwhile, Senate Bill 10, authored by Senator Hertzberg, was working its way through the legislature, and in 2018, it was signed into law by Governor Jerry Brown. SB 10 will require the creation of pretrial assessment services agencies in every county and replace the commercial bail system with supervised release monitored by a designated agency on conditions ordered by the judge. The commercial bail industry, threatened with extinction, responded by gathering the necessary signatures to qualify the ballot referendum to repeal SB 10, and now, on November 3rd, California's electorate will decide its future when voters decide the fate of Prop 25. A yes vote will uphold SB 10, a no vote will send the legislation and the legislature back to the drawing board. So I would like to lead off my questions to Robin Steinberg about her concerns with regard to the algorithms, and ask, if Prop 25 is defeated, as you urge, what changes would you recommend to achieve the goals that you would like to see achieved with the replacement of the commercial bail system?
Thank you for that. Those are two gigantic questions, and I will try not to take up all of the time answering either or both of them. But let me start with algorithms, since it was really a big piece of my opening statement, right? And why I think that that is what should actually dismantle the entire bill, right? The research is really, really clear that at every stage of our criminal legal system, from policing to charging to setting cash bail to sentencing, that there are racial disparities. Nobody at this point, I think, disputes that fact. So when you use data that comes from that system, that history, what do you expect is going to come out? Algorithmic risk assessments purport to predict human behavior and who's at risk to the community. But here's the thing. In determining the risk score, which will determine whether you stay in or go home, the data that gets used reflects systemic racism that has existed in our criminal legal system for generations. And here's how. It uses metrics like past criminal records, even though they're more a function of America's history of targeting Black and brown communities than they are about conduct that's happening in every community but only being policed in theirs. They use one's past failures to appear in court, even though we know it's more related to poverty and the lack of access to transportation than a disregard for the process. It uses past charges, even though prosecutors and police habitually overcharge. They use convictions and age, even though convictions happen more likely when you can't pay cash bail. And that we know disproportionately falls on the backs of Black and brown and low income communities. So you're more likely to plead guilty to go home, which means you're more likely to have convictions, which means that factor also is embedded in the systemic racism that goes into these algorithms. And we know age is even a factor that, while it may seem benign, is not, because we know that young people, and particularly young Black men, are the targets of policing systems in this country. So even age is not neutral. Really, in the end of the day, bias in, bias out. The conclusions you draw from those risk algorithms are only going to be as good as the data that you can put in there. And the data that we've been put in there, we know reflects a history of institutional and systemic racism at every single stage of the criminal legal system. And that's why so many people, in addition to myself, are raising concerns. In fact, last year, over 24 researchers from MIT, Harvard, NYU, Princeton, to name a few, and other institutions released a letter that made very clear, and I quote them, risk assessments rely on deeply flawed data that is neither a reliable nor neutral measure of underlying criminal activity. Decades of research has shown that for the same conduct, African American and Latino people are more likely to be arrested, prosecuted, or convicted than their white counterparts. Risk assessment that incorporate this distorted data will produce distorted results. These problems cannot be resolved with technical fixes.
Well, John Bauters, excuse me, Robin, but John Bauters, weren't these concerns addressed by Senator Hertzberg when he introduced Senate Bill 36 in 2019?
Yeah, in some ways, but let's be really clear. Robin is 100% on point. I don't dispute any single thing she just said. And I'm actually, it's a weird place to be with a fellow defender up here in a debate about something we both want fixed. And the funny thing is the bail agents, I mean, the only disagreement I think I have with Robin is being on the side of the bail agents in this for good reasons. I totally get her reasons, because they don't have to show up here today because they know they would lose in the argument with either of us about what the bail system does to people in and of itself. But SB 36 is one of the two things that I would say in response to Robin's points, right? So there are these huge institutionalized racist components to all the elements of the justice system, not just pretrial and risk assessments, right? So judges are biased, judges are racist. And currently under the current money bail system, a judge can choose to put their finger on the high end of the bail schedule when they don't like the way someone looks or where they come from or the language they speak first, or their age or gender or anything else. The way we sentence people, disproportionate criminal sentencing in favor of putting Black and brown people in prison for far longer terms and sentences, far harsher forms of post-trial supervision, conviction, and release standards. So the things she said are true. They extend across the whole system, right? And so we're looking at one component of the system. And you know, I'm not speaking for Robin, but I think the argument that's being made is, well, this is simply it's just amplifying, or it's just concentrating around some of these elements. These risk assessment tools are going to use data like criminal records, like arrest histories, things that she's mentioned, I agree with. It's going to use those, and it's going to be used and put into a report through some algorithm that is going to tell the judge whether or not a person, where they fall on a risk scale. And SB 36 is a companion piece of legislation because there's two key pieces that you have to think about here. One is, what does SB 36 do? And the second is just the practical nature of the legislative process and how quickly the knowledge and understanding around this issue has evolved in the last 5 years. So SB 36 has 3 basic requirements regarding pretrial risk assessment tools that aren't actually the case anywhere else in the country. So the one thing I would slightly disagree with is the notion that risk assessment tools and how they've been used elsewhere, while I agree there are faults to them, it isn't going to be exactly the case here in California. So beginning in 2021, and for every 3 years after, the tool has to be validated for its own accuracy. That's not validated by law enforcement. That's not validated by the pretrial assessment agency. That's validated by social workers and other people who use social scientific data about correlations between risk and certain factors like the ones Robin mentioned. How long has a person lived in the community? Are they employed, et cetera, things like that. It also includes some of the criminogenic things that she mentioned, like criminal histories and records. But that data has to not just be collected and validated, it has to be validated for the community it's going to be used in. And so that's a difference from the way the current risk assessment tools are used in most jurisdictions. It has to be validated on the community it's going to be used in. Second, they have to make the public has to be made aware of the criteria, the weights and the scoring that are going to produce the results of these things. So whereas right now, a lot of it is proprietary in nature, and jurisdictions that are implementing risk assessment tools don't share information about the algorithms or how they're weighting information, SB 36 is actually going to compel some of that to be brought to light. It's actually going to put into the spotlight, how is this information used? It's going to allow there to be greater review by the Judicial Council and the public, and it's going to have to be reviewed annually. And then the last part about it is that annual review and that annual publication by the Judicial Council is going to invite in greater discussion about this. So there's a difference between the use of the current risk assessment tools and then the way it would be used under SB 10 and SB 36. But then the second piece about this is really about how do we move the movement forward? And I'll be honest with you, all my years of litigating before I got into policy work, I would probably be sitting in the exact position Robin is in. But I've spent 8 years doing policy and introducing legislation, and legislation is created differently than case law. It is different than it appears in practice. And the reality is that we have a multi-million-dollar industry heavily influencing legislators in Sacramento, weighing in on how this gets done. And they have created so many loopholes in the law for themselves that allow them to escape the responsibilities that we created the system that they were using. They don't have to bring people in. There's so many continuances and other things they can get that avoid the obligation to bring people who fail to appear, that we're actually paying for it from the public coffer anyways. And so the reality here is that in order to make the change that we want to see, it's got to be kind of a two-step movement, and we have to make this change. And I will just note that all of the folks who worked on the coalition who left the bill initially supported risk assessment tools. And we came into a greater place of knowledge. I'm a graduate of the Pretrial Justice Institute on pretrial reform. And that was a position we all held, was that risk assessments were the way to go. In February of this year, they said, you know what, not a best practice. The difference is California's kind of caught mid-stride. And so the question is, how do we move this forward? And should there be, and can there be, to Robin's point, more things that are done? Absolutely. We still need to pass Prop 25 in order to get there.
I'm going to come back to Robin with what I think is the more difficult question. Let's assume that Prop 25 is defeated. And going into 2021, we have the bail schedules, which I think you both agree are horrible. How would you propose going about doing away with bail schedules, and what would replace them to guard against the inherent bias that you fear judges have?
Sorry, I was muted for a second there. I apologize. So, that's, again, another sort of really big question. And so I want to start sort of a little bit big and get a little more specific, right? The cash bail system is a symptom of larger systemic issues, right? If you walk into any jail in this country, any jail in California, you are going to see thousands and thousands and thousands of people with mental health issues, addiction, trauma, severe poverty. And we have to really begin to think about, as we reimagine a pretrial justice system, we have to address that reality if we're going to find a better way to create a pretrial justice system, right? So the way we do that, I think, it shouldn't be a paradigm of cash bail or SB 10. I just reject that as the binary choices, right? The way we do that is we need to begin, when we think about what a system should look like, to literally shift our entire lens away from isolation and punishment to an entirely new paradigm that asks the question, what do you need? What supports can we put in place? What services do you need to be connected to so that you can be successful while you're out and back in your community while your case is pending? Now, that may sound theoretical, but it's really simple. It is moving from, instead of looking at people from the lens of, are you a risk? You are looking at people through the lens of, what are your needs and what supports can we put in place? I want you to think about somebody in your own life, right, who you know is struggling with a mental health issue or an anger issue or trauma or addiction. You likely don't see them through the lens of risk. You likely see them through the lens of, what can I do? What can we help? What can we connect you with? And how did we fail you? The reframing I'm suggesting will actually shift everything and actually should guide whatever new system we create. So rather than use risk algorithms, we need to tap into our humanity, and we need to work on needs assessments, individualized needs assessments of anybody coming into the system, and really think about what we can do to put in place to support them. That's going to cover most people. That's going to allow most people to go home and be free as long as they're receiving those supports, good court reminders, right? And being connected to services. And we obviously need to use diversion as well, but that's another conversation. And I want to be clear about something because I don't want to sound naive. That doesn't mean that every person is going to be able to get diverted or even get out of jail. And it doesn't mean that there's no accountability for harm. But what it does mean is that incarceration before conviction should be reserved for the very limited exception. We can create a pretrial justice system that does individualized assessments and determines needs, and then build the infrastructure to respond to those. Rather than create pretrial assessment service agencies, we could actually think about like creating community care centers that support people during the pretrial process. We can allocate resources away from the criminal legal system, particularly before conviction, into those communities to provide those services and support and infrastructure. And in those rare circumstances where there aren't services or supports available to support someone's needs, and detention may be the only option, then obviously the burden should be on the government, and it should never shift to the accused. Another problem I have with SB 10, but that's a detail we don't have to go into. The burden should stay on government, never shifting to the accused, to prove that the only way to keep the community safe is through pretrial detention, and that must be proved by actual evidence, not hearsay, in a transparent court hearing where the accused has counsel, can question the witnesses, and can call witnesses on her own behalf. There have to be strong procedural safeguards for those very exceptional circumstances. But understand, we are creating systems around the exception. We can create a system that addresses people's needs, supports them, allows them to be home in the pretrial context, and reserves for the rare exception procedural safeguards like I have outlined.
John, I'm going to guess that there's nothing Robin has just said with which you disagree.
I have two things I disagree with.
Okay, well, and tell us what those are, but then tell us as a legislative advocate what the legislation would look like that would accomplish what Robin has described.
That would be my second thing. Well, that's my second thing. So here's the thing. Robin and I would be great friends at the bar after work. I appreciate everything she just said. I really do. But I have two places where I disagree with Robin. The first one I have to line up is it absolutely is a binary choice today. I disagree with that characterization. Voters are being asked a very clear question. This is a referendum. And as a lawyer, referendums are a question about, should the people of California affirm the legislature's action in Senate Bill 10? It is a yes or no question. It is a binary question, okay? And the outcomes are binary in nature. So the yes campaign means we eliminate the cash bail industry and we implement the pretrial risk assessment programs that are implemented under SB 10 with risk assessment tools and the entire process that's outlined in the bill, okay? And if we don't, we end up keeping the cash bail system. And as I outlined in my introductory remarks, there's legal analysis that says when the voters basically invalidate a law in California, that means the legislature is precluded legally from taking action because the court will interpret that the people have said, no, we wish to keep the cash bail system. And when voters do that, the legislature is not empowered to undo that. So it has there's a real like an all or nothing here from getting the bridge across 25. So I disagree with the characterization that it's not a binary choice. But what I think she's speaking to is the ideal, what is actually the ideal for a system? I completely agree that needs assessment is necessary. I completely agree that we should do an analysis of how to help a person overcome the things in their personal life and in the community that brought them to the point where they arrived at the door of the criminal justice system. I do not disagree with those things. The problem is a practical nature goes to your second question, Judge Eskin, which is legislatively. And I can't speak for Robin, and maybe the one advantage I have is having worked on all the legislation on criminal justice reform in California for the past 7 years. And the reality is that the price tag of that is unconscionable to the legislature. The price tag of needs assessment, because the questions we received when we asked that were, well, who is going to implement needs assessment? How are we going to pay for it? Is it an expansion of an existing service or program? People today under mental health realignment, under human services realignment in California do not have to do that. Counties will have a unfulfilled mandate, a state mandated local program, which under propositions that have passed before will require the state to reimburse counties. The state then looks at that and says, well, what is the value? If Robin is our client and Robin comes in and we identify 4 needs for her, okay, the county, then what are they supposed to do? Turn their back on those needs? Great, here's your needs. I hope you have help. No, the county is then going to say, we're going to have an obligation, a liability, now that we've identified these needs, to service those needs. And the reality is that, I think Robin would agree with me, that the needs of defendants are sometimes far more expansive than the services many counties offer. And so the reality is that when we proposed that, because that was on the table, that was rejected outright by legislators across the spectrum because of the fiscal cost. So at a principled level, I completely agree with Robin. And in a world where she and I ran the justice system and the purse had no bottom, we would absolutely do that. But the reality is that there's a fiscal reality to all of these proposals, and there isn't a fiscal realization that can happen in California today or anytime in the near future where we can do that. And we looked at pretrial assessment systems that actually begin to reduce harm, begin to take people out of jail, okay, as the first step. And our hope is to build in needs assessment. To my earlier comment about this is going to be a tango. We are going to take steps together, and we have to move forward. But we can't simply say, let's just clear this, take this away. Voters should just reject it. There's not a binary choice, and then we'll just come back with the utopian version of pretrial. It will be rejected out of hand, and I know that because I've asked it.
Thank you, John. Dr. Niemer, I think it's time for Professor Smith to field some questions from the audience.
Yes, indeed. We have a number of questions coming in, and just because I know, Professor Smith, you have to teach in a few minutes. So let's get as many of these questions in as we can, and so I'll let you decide which ones to bring in.
Okay, thank you, Judge Eskin, and thank you, Dr. Niemer. I should make a full disclosure. I have, within the past 6 months, made a financial contribution to the bail project. It had nothing to do with this
We don't hold it against you. We don't hold it against you. It's a good.
I am grateful for that. Thank you very much.
It's a good investment. No problem.
It was in recognition of their larger mission. But let's get on with the questions. One question I believe either of you could answer, because I'm sure this is of interest to a lot of members of the voting public. How would those charged with domestic violence be treated? Would they be given home detention? I believe there's some specifics in SB 10 on that. I don't know who wants to take the question. Go ahead, John.
I'm happy to go first, only because Robin's been forced to go first and not respond to me. So she should get a chance to respond to me and have the last word. You know, the SB 10 has essentially the way it would work. People who are arrested for a misdemeanor, there's a list of 10 exceptions to being released on own recognizance. People arrested for a misdemeanor are released on own recognizance. One of those exceptions is misdemeanor domestic battery. Obviously, felonious domestic battery and any type of sexual assault is also excluded. So the person wouldn't be eligible for either cite and release or book and release. Cite and release meaning the law enforcement agency at the point of contact releases them with a notice to appear, a date to appear. Book and release meaning they're actually taken to the jail, they're booked, and within 12 hours they're released under SB 10, which, by the way, is not the law today. It would be one of the most expedient book and releases that we'd have, because currently people sit pretrial, can wait and languish for days waiting to see a judge at arraignment. So a lot of people would be released within 12 hours under that rule. But to the domestic violence situation, a person who's charged with that has to undergo the risk assessment tool that we've discussed. They have to have a risk assessment done, and within 24 hours of being booked, they have to appear before a judge at arraignment. There's a small exception for these magistrates, pre-judge situations if a county elects to have one, but essentially the vast majority of people would appear before a judge judge. The risk assessment tool will be one of a number of things, including victim statements, other witness statements, facts from the arresting agency that would be used by the judge in evaluating what set of condition or conditions could, a non-monetary in nature, could be used to secure the person's return to appear at court, while at the same time protecting the public, protecting the victim and any other witnesses. And there are some exceptions where if there are some things that the defendant has done, the defendant would have the ability, the prosecution would have the ability to hold on to that case further for up to 48 hours to file a motion to seek to detain the person if they thought there was no set of conditions that would secure the person's return in the public safety.
Okay, thank you. Ms. Steinberg, did you want to add anything to that?
No, that's a rendition of exactly what the bill lays out. I mean, the question was, what would the bill do if SB 10 passed? And SB 10, one of its problematic natures to me is that it actually makes charge-based distinctions in sending somebody from booking to the arraignment rather than allow them to be free at the initial outset. But that is exactly how SB 10 would deal with a charge of domestic violence.
Okay, so the next question I have from the audience is, in the event the proposition passes and SB 10 takes effect, can the risk assessments it provides for, can they be modified? And if so, who is in charge of the modification?
Well, that is the crux of our disagreement, right? The entire architecture of SB 10 rests on risk assessments. I mean, at every single stage, the risk assessment tools are used. So I don't actually think you can move forward with SB 10, vote yes on the proposition, and then be able to say, oh, you know, we want to do that, but we want to pull out the risk assessment tools. Can't be done, and they can't be fixed. So if we appreciate and can acknowledge and can accept based on the experts, not on me, that they can't be fixed in terms of racial disparities, then it really gets us back to the question we were at the beginning, which is, are we better off gutting it and starting all over again with the recognition that systems shouldn't be built upon algorithms that will further embed, perpetuate, and codify racial disparities, particularly at a moment in history where we are now. You know, I listened to John, who's obviously really thoughtful and really smart, and we agree on a lot of things, but when I hear you talk about the cost of doing a needs-based assessment, my head wants to explode. There is no greater cost than putting somebody in a jail cell. There is no greater cost to the American taxpayers than pretrial detention, which is $14 billion annually. There is no greater cost to a person to hold them in pretrial detention as their life falls apart and they lose their home and their job and their status and their education. There is no greater cost to low-income communities of color across this country than the systems that we have. So if it cost us a little bit more, and I'm not even sure that it would, I don't actually think that it would, to do a needs assessment instead of use tools for risk assessment, that's actually something I think the taxpayers of California would be willing to pay, because California should lead the way in redefining what a pretrial justice system looks like and rejecting the notion that human beings should be seen strictly through the lens of risk. And I said, there's a limited number and a rare exception where you have to think about holding somebody pretrial. But for the vast majority of people, if you just looked at this through the lens of need, created the support systems that people need, not probation, not law enforcement entities doing that work. And you want to talk about expensive? How about those pretrial assessment services? How about the infrastructure that you're going to create that's essentially probation are going to do those assessments? That bureaucracy and that money is going to pour into that system, and rolling that back will be also impossible. But even if it wound up being a little more expensive to do a needs assessment, in the long run, it's better for individuals, it's better for families, it's better for communities, it's better for America. It's going to wind up being less expensive. You're going to have fewer people with criminal convictions. I mean, we see at the Bail Project, when we bail people out, 1/3 to 1/2 of the cases get dismissed. That means that that person now doesn't have the criminal conviction they have to now navigate for the rest of their lives, preventing them from moving forward and having economic mobility for themselves and their family. So all in, it's a worthwhile investment.
Mr. Bauters, did you have a quick response?
Yeah, I would just say that I don't in principle disagree with the arguments that are being made. They don't resonate with the people inside Sacramento, and they would very seriously disagree with it's a small added cost to do these things. They initially ballparked it in the hundreds of millions of dollars to do needs assessment, which they found unpalatable and unsustainable to the state budget. Again, like I said, I think the only difference, and this isn't meant as a slight, I think what Robin's doing is very important work, but my job is to work inside Sacramento. I have worked on over 25 pieces of major reform legislation. I have worked on 4 ballot measures statewide that have passed. I have been doing this for the last 8 to 9 years after working as a criminal defense attorney. So my principles are rooted in everything Robin is saying, and I do not have any disagreement with the arguments she's making, but the question about whether to endorse or not endorse or support or not support a ballot measure, which is based on a law that was passed, which was a compromise piece of legislation that was a deal reached between the legislature, the courts, and the executive branch to make a complete system overhaul. It required that there be compromises that people like Robin and I would not choose at the first blush. I would not choose to have the inclusion of certain types of criminal offense-based things that she mentioned, like, offense-based filtering of people for risk assessments or not. I would not choose that. I did not enjoy my conversations with the Supreme Court Chief Justice, no offense to Judge Eskin and his friends. I did not enjoy my negotiations with them at the end because there were a lot of things they wanted that would have made this bill worse to people like Robin in their position. But the reality just remains that when you look at the situation and the problems that one sees with risk assessments, all of that bias exists today. It is not removing risk assessments, does not change the implicit bias of judges. It does not change bias in sentencing. It does not change the arrest system. And that doesn't mean we should just say, oh, well, it's just going to be here. But we have to look at how can we strategically move forward. And SB 10 removes one of the major players, and it removes wealth-based influence. And independent analysis shows many more people will be released pretrial, which doesn't get to her the paramount goal, which is needs assessment and a needs-based system, which I agree with, but it moves us away from a wealth-based system into one that's in some ways harm reduction-based. And she may not agree with that statement, but I do believe it is a movement in the right direction. It is not a complete solution, but we have to keep moving in that direction. And I really do believe that the arc of history tends toward justice.
But one just quick thing I have to say. So, in the conversation about cost, and it's going to cost hundreds of millions of dollars. The correctional budget in California for this 2018 was $15.8 billion.
Preach, sister, preach. I'm totally with you.
We can't find a few $100 million to do needs assessment to better support communities that have been historically marginalized and disenfranchised is just laughable in the face of that. And here's the thing. The cynicism that's implicit in your argument that somehow legislators won't take this back up, that somehow, there's racial bias, but we know there's racial bias everywhere. You know what? The moment in history is now to actually say, you know what? No more. Not only if it exists, then let's get rid of it, but let's not codify it. Let's not perpetuate it. Let's not build it into a new system. The moment is right now in this country. People are out on the street tonight marching for one thing and one thing only, racial justice in this country. And it is not going to be good enough for us in California or the legislators that represent us to simply say, we know there's racial bias. We'll set up a committee and they'll look at it. And every 3 years we'll have a report that'll show where the racial disparities are. This is the moment where people have an appetite to actually face and reckon with our history in this country of unbelievable racial terror and racial injustice. Everybody is at that place. If there's not this moment now, we'll never have it. So why don't we give it a try now? Say no on the proposition, hold them accountable, and tell them that the moment to address this issue is now, not to continue to do it the same way we've done it and compromise. The compromise, John, doesn't affect me and you.
I agree with that. I would like to respond briefly to that.
Actually, we're almost out of time, and I want to squeeze in one more quick question.
May I make a quick response to that? All right.
Okay. So if we eliminate cash bail, does that mean that the courts are going to be tied up spending more time reviewing these decisions made by computers, not only adding to the cost, but also adding to the court backlog? Would either of you like to respond to that?
Don, you can use at the front of your argument what you wanted to say to me, because that's only fair.
Yeah, the only thing I want to say is in response to the last thing, I need to say this, that the history of ballot measures in California, every time the voters have approved it, there's a series of bills that come in the following year that attempt to undo or undermine reform. And legislators have always been told and have always leaned from leadership's guidance on the people wanted it. So people hold off on the reforms, on repealing reforms or eating away at them. It sends a very different message to the legislature. If people vote no for what you believe is a conservative and oppressive form of bail reform, they're going to say, why the heck would we take up a more progressive one? And you may say it's the moment. And the reality is that nobody took up the policing bills at the end of session in California. They didn't go to a vote. They were withheld from the floor in the assembly. 41 votes, the bare minimum for paid family leave in California. So you can think this is a progressive state, it's going to do all these wonderful progressive things, but the bottom line is that Californian legislators have not had a history of voting for progressive things, whether we want to believe that or not. So if we send a different message this time that says, hey, you know what, we don't want bail reform, what legislator who has wanted to hide, who tried to hide during bail reform, we only got 41 votes for SB 10, what legislator is going to then stick their nail out when the bail industry is still there and law enforcement is still there and say, you know what, I'm going to take up this more progressive mantle after the voters killed the thing that was more moderate. They're not. So
we can only pray that at this moment, as opposed to 2 years ago, when the power of police unions step up, people are less influenced by it these days. And I do believe that. And I do believe it's why the time is right. But we should get back to the question that was asked.
And the question at hand was about
the question was, if we abandon cash bail, will that mean the courts will be tied up hearing more hearings, reviewing the decisions of the computer?
No, not at all. So? In short, the estimates from the independent people doing the evaluation of this is about 35% of the people would be released immediately under the site or book and release. So they wouldn't even have hearings for that. And essentially it's just one more data point that the judge has. So there's not changing the scope of these hearings. It's not adding time. In fact, we actually believe it will reduce the amount of time spent at arraignment. So judges will have more time to handle other types of criminal and court matters that they don't currently get to because of bond court.
And I got to come in as a timekeeper. So Judge Eskin, we're going to go to closing remarks. I think that should wrap it up. So I would say anywhere kind of like a minute most. I'll leave it to you and who you like to call on first. And then we'll go back to the polls.
Well, let's call on Robin to give a brief summation and then turn to John. And I just don't know why John brought up the family leave bill. But go ahead, Robin.
You know, here's what I would say in closing. I think I've said most of the things I really wanted to say, but this is not an easy issue. This is a complex and nuanced and difficult conversation to have, and one that I think requires all of us to look in the mirror and really ask ourselves what part we play in what our criminal legal system looks like, what part we play in perpetuating systemic racism and institutional racism, and how we're all implicated in this system. It's something we all have to care about, and I assume the people who've signed in care about this very deeply, because every time a prosecutor gets up in a courtroom and says, I'm here for the people of the state of California, they are doing something in my name and your name. And so it's really important that we engage with this. And while, you know, whichever way you decide to vote, I would say vote no on the proposition. I would have some faith and some optimism and some hope that we could get the legislation to take this back up the legislator. I believe that because across the country, legislators are taking it up all over the place. I think the appetite's there, and I think the potential is there. In the meantime, there are lots of other ways to think about how we get as many people out of jail as possible, particularly in a time of COVID, and how we decarcerate as quickly as possible. One way to think about that is hold your district attorneys accountable. You have a district attorney in San Francisco that doesn't ask for cash bail. You may have one in Los Angeles, given the election coming up. So there are other ways to get to where we need to get to. We don't have to sit around and wait while people wait in jail cells. That's unconscionable as well. There are other things we can be doing, right? We can really be thinking about how do we hold judges accountable? How do we demand that they follow the law, which is they should be setting cash bail in an amount that somebody can actually pay? That determination is supposed to be made. The Humphreys case here in California has now been made clear that that is the law that judges are supposed to follow. So you should hold judges accountable to that too, because then people would actually be able to get out while we're working out new legislation, just like you should hold your prosecutors accountable, know who you're voting for, and ask them to stop asking for cash bail because they have the power to change it. So do judges overnight.
So I want to begin by thanking the Colleges of Law for inviting me on very short notice to participate in tonight's debate. I want to thank my fellow participant, Robin Steinberg, for not only just being a champion in the cause of defending people and their civil rights who are facing an oppressive and institutionalized racist system, but for her work at the Bail Project. It's important to recognize that both of us are working with real people who have face real life and life-changing consequences because of the systems that we have in place, and there's a need to change them. And I would say that as you've seen this evening, I don't disagree with the the content or the substance of the things that are being said, that the issues that she takes with the bill, the places where the bill could be better. But again, this is a binary choice. And I think the place where I would disagree and I would ask people to really think about how we move forward is, while yes, there is a movement across this nation, and while yes, other legislatures are taking this up, at the time the California legislature took this up, risk assessments was what the National Pretrial Justice Institute and advocates all across California advocated for. We put it in a bill together. Grassroots groups, groups that pay for the bail, Black mothers across the state, all got together and we were working together to move this bill forward. When this bill passed and then better practices were brought to light, people changed their point of view. The bill has been frozen in time by the referendum. The legislature can't act to change the bill while a referendum is pending. But there also is the legal consequence, which my opponent didn't address this evening, which is the fact of the matter is that once, if Prop 25 fails, the legislature would be precluded from acting. So all the good things that she's advocated for, we can't actually bring back to the legislature. And legislators, even if that was legally allowed, even if that was arguably the case, legislators aren't going to take it up because they don't take things up that the voters have rejected. They don't look at that as something that they should be as a priority. So what I would say is, yes, there's ways to make this better. I'm happy that the field of pretrial reform is evolving as quickly as it is, and that better practices are coming. There are better ways to do this, and that this can be part of a more national movement to make that happen. But in order to keep that momentum going and to get back at the table without the bail agents in the room, without their money polluting California's legislature, we need to vote yes on 25. Thank you for your time.
We'll make that the final word. I know we're at the bottom of the hour. What I'm going to do now is we wrap up and do acknowledgements. I'm going to relaunch the poll. And if people want to play the game to the end, the poll is back open. You can jump in as a yes or no, or you can be undecided is there as well. People are doing the poll. So while we let the poll finish out, I want to thank our panel today, John Bauters, Robin Steinberg. Thank you so much for joining us. This was a passionate, engaging, this is everything we hoped and expected with this program tonight, and you made it possible. I want to thank both of you for joining us. And of course, our moderators, Judge Eskin and Professor Smith, I want to thank you as well. And we have a number of students that are with us tonight and graduates with us tonight. We have the Dean of the Colleges of Law with us tonight, Jackie Gardina, the Chair of our Board of Trustees is with us. I'm just doing some acknowledgements as we wrap up. So I'm going to end the poll in 5, 4, 3, 2, 1. And let's get the results. So here we go. I'm going to put it up on the screen. There has been some movement, so we will have a winner tonight. And what I'm going to show first, I'll just put it up here on the screen, is the poll before we got started. So that's up first. So, and here it is. So at the beginning of our program, hopefully, can you all see this from the panel? Judge Eskin, can you see it?
Yes.
Yes.
We had 26% said yes, 13% said no, 62%, a big number, said undecided. Let's roll down. We re-polled the audience. 63% said yes, 15% no, and 22 undecided still. All right, and then the winner of tonight's debate, getting the most movement, as you can see from the first to the bottom, John Bauters. You had 3 hours to prepare and you won the debate. We want to thank you for your contributions. How do you feel?
I just want to thank my colleague for doing a debate. The only winners in the debate are the public and anyone who participates. It's very easy to declare someone a winner, but I will share this with my partner because she's a partner in the pursuit of justice. And the bottom line is that we're all winners. We're working towards that goal.
Thank you, John. We'll be happy to work with you.
And with that, we're going to sign off for this evening. The recording of this program will be available in the days ahead. And again, we'll be back next Thursday night for Proposition 16, Affirmative Action. We'll hope to see you all then. Until then, have a good evening and take care and have a good night.
Good night.